Hey everyone, welcome to our webinar on online safety and content moderation laws in Europe. For those who don't know me, my name's John Brunning. I'm a partner here in the technology data team at Field Fisher. And along with Frankie, one of the speakers today, I co-head the firm's technology regulation sector group. So as you're probably aware, across Europe, we're seeing a growth in regulation impacting technology businesses, from cyber to platform to data, and of course artificial intelligence. And it won't have gone without being noticed that the press has been dominated by the impact of AI on businesses for the last few months. But I think online safety and content moderation is just as an immediate issue for artificial intelligence than for artificial intelligence. And there are three main reasons for that. The first is the regulations are more imminent. So the Digital Services Act in Europe is coming in force in February next year. We're seeing more disparate regulations. So as well as in the EU, UK and Ireland, which is what we'll talk about today, we're also seeing sector and content specific regulation in areas like terrorism. And we're also seeing countries and regulatory regimes taking different approaches to how you might moderate content and protect those online. And we'll touch a bit on that as well today. Finally, there's the ethical question. I'm sure we can all agree that we want our children to grow up in a world that's safe online environment. I think the question for regulators, for all of us, is how do we do that, and ultimately who's responsible for policing the internet? Final thing to say on this before we get on to today's webinar is online safety is something that impacts a broad range of businesses. So it's not just the obvious social media companies that are caught, but it's also businesses operating in the gaming space, in internet dating, travel sites, and even B2B SaaS providers to some extent. So there is a really broad spectrum of businesses across sectors that are caught. So on to today's webinar. Here at Field Fisher, we're really lucky to work with leading technology businesses and brands who are operating in sectors which are impacted by online safety. And as a result, our tech and our regulatory teams across Europe are being asked by many of them to help work through what these regulations mean for them and how they need to comply. So what we wanted to do today was to boil down some of these commonly asked questions in three of the major regulatory developments on online safety. So the EU's Digital Services Act, the UK's Online Safety Bill, the Irish Online Safety and the Irish Online Safety and Media Regulation Act. We've also had a number of questions from you, which we've tried to distill into these questions. So the aim is here that while everyone is at a different point in their journey, some people have quite well-developed compliance programs already. Some are just coming to this fresh. There's something here for everybody. And I should say, if you do have any questions throughout the session, do drop them into the chat or email us after the session, and we'll try and see if we can get to those. So now on to our panel. I'm delighted to be joined by an international panel of experts on online safety. First up is Tim Van Knecht. Tim is a partner in our Brussels office, and he's been working with businesses on a wide range of EU technology regulation, and in particular on the EU Digital Services Act. Frankie Everett is a senior associate in the regulatory team here in London, and as well as co-heading the sector initiative on technology regulation in Europe, Frankie has also been looking at and advising on the impacts of the online safety bill for businesses in the UK. And finally, Sinead Taff is a partner in our public and regulatory group over in Dublin, and she's been looking at the impact of the Irish online safety and content moderation laws there, and is going to give her view on that. And finally, I get the easy job, which is I ask the questions and then let our team of experts have to answer them. So, on to our first question. Perhaps starting with an easy one. What are the key differences between the three pieces of legislation, and perhaps given the development of the Digital Services Act, Tim, that's something you might want to touch on first.
Yeah, sure. Happy to do so, John. So the Digital Services Act is really one of the cornerstones of the EU digital strategy. What the Commission basically did was pledging that it will make illegal in the online world what is already illegal in the offline world. And so it is as such not an entirely new piece of legislation. I think that's important to note. It's an evolution of the e-commerce directive that was adopted about 20 years ago, to which a layer of new obligations was added. And so essentially the DSA has two key objectives. The first one is to create a safe online environment for users of online services. That's really the part where you will find the notice and action and content moderation provisions that we will focus on in this webinar. And then secondly, there are a series of new transparency and accountability obligations that are being imposed on providers of different kinds of online services. And we're speaking here about requirements of what should be included in terms and conditions, increased transparency in the field of targeted advertisements, a prohibition on the use of dark patterns in interfaces, and so on. Now, what is important to bear in mind is that different rules apply to different types of online intermediaries. So we actually have a common foundation that applies to all online intermediaries. And then there are more specific rules that apply only to hosting providers. And within the category of the hosting providers, there are even more specific rules for online platforms and marketplaces. And then finally, as you will probably have heard, there is a last layer of rules that only applies to the so-called VLOPs, the very large online platforms or search engines. So given the focus of today's webinar, if we specifically drill down a bit more on the notice and action mechanism, it will apply to providers of hosting services. And a hosting service is defined as an online service that consists of the hosting of information that is provided by and also at the request of a recipient of the service. And I think that is really key to highlight. A recipient of the service can be both a consumer and a business. So the scope of the DSA is really not limited to consumer-facing hosting providers. B2B hosting providers also need to comply. That is very important and a bit overlooked at times in the market. On top of that, in addition to this material scope, the DSA also has a broad extraterritorial scope. It really doesn't matter where the hosting provider is established, whether it's established in the EU or not. What matters is the fact that it offers its services to recipients which are either established or located in the EU. And so if you are caught by the DSA scope, well, then you essentially, if I simplify it a little bit, you have two key obligations. First of all, if a competent authority gives you an order to act against illegal content, well, then you must do so without undue delay. And to facilitate this, the providers need to designate a single point of contact and publish that person's contact details online. And secondly, you must offer an easily accessible online mechanism for the wider public to report alleged illegal content. And there as well, if you receive such a notice, there is an expectation or a requirement rather that the provider acts diligently. So that is the obligation to act when you become aware of illegal content. What I would like to add as well is that the DSA now really makes it clear, contrary to the e-commerce directive, that a hosting provider is not subject to a proactive monitoring obligation. But of course, as you can imagine, they are encouraged to carry out so-called own initiative investigations on their platforms. And here as well, the DSA codifies case law of the Court of Justice, indicating that if they do so, they don't lose the protection from the safe harbor mere hosting liability exemption. So that is a very welcome clarification. And then finally, to wrap up on this sort of quick intro of the DSA, a few words about sanctions. It's not our favorite topic, but we need to talk about it. Enforcement of the DSA will actually be more similar to the enforcement of that we see in competition law rather than what we see under GDPR. So what does it mean? Most of the enforcement will be done at a national level, except for the VLOPs, where it is the European Commission that will be responsible for policing and enforcing the rules on them. As we have seen it with all these acts that the Commission has adopted in the last few years, there is again a board that is created, a European Board for Digital Services. The task of this board is to issue opinions and recommendations. So it is not unlike the EDPB. There is no one-stop shop mechanism like we know it under the GDPR. And to just give you a flavor of how important the EU considers the rules under the DSA, if we look at the sanctions, the administrative fines, it's a very similar level to that we find in the GDPR, but the maximum fines are even higher. They can go up to maximum 6% of the total worldwide annual turnover. So that is certainly an indication of how serious and how important the European Union considers this topic.
Thanks, Tim. You did a great job of getting the DSA summarized in such a short time. Frankie, do you want to talk a bit about the online safety bill in the UK? Obviously not as advanced as the DSA.
Yeah, thanks, John and Tim for that intro. So most obviously, I guess, the online safety bill is the least mature of the three pieces of legislation that we're covering today. It hasn't entered into force yet, so everything we say is sort of subject to the caveat that things could change. More than just takedown obligations, the online safety bill is a risk-based approach to minimizing harm for regulated services. So I guess a key distinction between what Tim was just explaining about the DSA is that the online safety bill will require platforms to probably take a more proactive approach about content moderation. Briefly on material scope, just to mirror Tim's comments. So the scope of the online safety bill will be user-to-user and search services. So user-to-user being defined in the bill as services which allow users to encounter, upload and share content that is generated directly on the service by another user. And then search services, sort of matter-of-factly being search engines and other ways of searching multiple websites and databases. So that's quite a big distinction between the material scope of the DSA. Territorial scope, so to be a regulated service under the online safety bill, that service must have links to the UK, and this will depend on whether it has a significant number of UK users or whether the UK is a target market for the service, or alternatively, if it's capable of being used in the UK by individuals. So we can see the focus there is therefore on where the user is located rather than where the platform is situated. And then finally, just one kind of key distinction about the online safety bill when we're comparing it to the DSA is this requirement in relation to harmful content. So some of the harmful content requirements have been removed from the most recent version of the bill in January. They took out the requirements to protect adult users from harmful content, but importantly, other harmful content requirements do remain in. So particularly for child users, platforms will be required to identify and minimize the risks of harm to child users. So that's kind of one key area that platforms will need to be aware of.
Thanks, Frankie. Possibly part of the reason that we are struggling to get some agreement on the UK online safety bill. Sinead, how is Ireland approaching this?
Well, the first thing to say, John, is the Digital Services Act that Tim is discussing is directly applicable in Ireland also. Certain provisions of that act will require implementation by way of national legislation. and that will be addressed in the Digital Services Bill. The general scheme for that bill was published in March 2023. And the Online Safety and Media Regulation Act that I'm discussing today is a distinct piece of national legislation that was introduced in Ireland to transpose the revised Audio Media Services Directive. So it's important that the 2022 Act is not equated with the Digital Services Act, nor is it seen to be implementing the Digital Services Act. And just to briefly provide an overview of what the 2022 Act does insofar as online safety is concerned, it amends the Broadcasting Act of 2009, and among other things, it establishes a new media commission with responsibility for introducing and enforcing a new regulatory framework for online safety. And Part 11 of the 2022 Act seeks to minimise the availability and spread of harmful online content by regulating the activities of designated online service providers through online safety codes. And the newly established Commission will have responsibility under the Act for designating the relevant online service providers that are to be subject to online safety codes. So relevant online service providers includes video sharing platform services and other information society services on which there's user-generated content available and which are under the jurisdiction of the state. It is important to note that the Commission is required to designate as a category of online services video sharing platform services, the provider of which is under the jurisdiction of the state. And the Commission will develop online safety codes that are to apply to those designated online service providers, and the codes will be binding. The safety codes may, among other things, set standards for content moderation, reporting obligations to the Media Commission, and the handling by providers of complaints. And the Act defines what is harmful online content, and we'll touch on that in more detail shortly, but we'll see that unlike the Digital Services Act, it includes certain specified non-illegal content that meets a risk test. What the Act also does is make provision for the introduction of a scheme providing for the making and resolution of complaints on the grounds that harmful online content is available on a designated online service. The Commission is required to prioritise when making those schemes for complaints about harmful online content that relate to or are directed at children. And it may be helpful to flag at this stage that this is different to the right to lodge a complaint under Article 53 of the Digital Services Act, which relates to the making of a complaint to a digital services coordinator, and that pertains to an alleged infringement of the regulation rather than to specific illegal content. So just to recap, only those that are designated by the Commission as being subject to online safety codes will be subject to the Commission's regulatory and enforcement powers under the 2022 Act, and we'll touch on those enforcement powers at a later point.
Lovely, thank you. So I think that one was quite an easy one. So let's move on to something a little more tricky. How do we assess what is illegal content, or in the cases where legislation is subject to it, harmful content? Tim, do you want to kick off with this one?
Sure, happy to do so. Where shall I start? I think maybe the first important thing to highlight is the fact that the DSA really only requires hosting providers to act in relation to so-called illegal content, and that's really, as Frankie mentioned, a big distinction with the online safety bill. So what is illegal content? It is now defined. It was not defined in the e-commerce directive, but illegal content is any information that violates the law of the EU or those of a member state. So a super broad definition. On the point of harmful content, there was actually a lot of debates as to whether DSA should also cover that. And harmful content is then information that in itself is not illegal per se by law, but harmful to society at large. And obviously fake news is a very clear example of that. Eventually, the EU really considered that it is quite subjective to consider whether something is harmful or not. So it would be put a big burden on platforms to assess that. And also, it would potentially conflict with the very important principle of freedom of speech. So the concept of harmful content was not included in the DSA. So that leaves, I guess, then the big question: how do you assess what is or not illegal content? And because of that extremely broad scope, it is really one of the questions that a lot of our clients are struggling with. What we try and what we advise when we engage in discussions with clients on this is to first ask yourself the question, as a hosting provider, how often do you receive today, or how often do you expect to be receiving notices of illegal content? And it is quite clear that for certain hosting providers, especially in a B2B context, SaaS providers, for instance, it will only happen occasionally or hardly ever. And in those cases, the hosting provider could decide to adopt or rely on an ad hoc approach where they really only assess the notices on a case-by-case basis. It's a bit different if you're a hosting provider that receives frequent notices because you need to act diligently. And to act diligently, you should ideally have a clear view on what are the legal provisions that may potentially be infringed on your platform. And so you should have ideally an inventory of relevant laws readily available so that you can quickly cross-check that against the notice of alleged illegal content. Obviously, that in itself, creating such an exhaustive inventory is, well, practically speaking, impossible, because you would need to create an inventory of virtually any member state law or any EU law. So that is not feasible. And so what most of our clients are doing is the following. They really look at the nature of their hosting service, and based on that, they actually, in most cases, have a relatively good idea of what issues they may come across. So, for instance, a video sharing platform will certainly need to know about copyright laws, and online marketplaces will need to be familiar with counterfeit laws. But if you are a finance SaaS B2B solution, you can probably disregard these kind of laws because they will not be very relevant, and you're unlikely to receive notices about those laws. So you try to define your so-called usual suspects, and based on that, you can then create an inventory of laws that will be most likely to be relevant when you're facing illegal content, and that will allow you to act diligently. And if you then exceptionally receive a notice that is not covered by your inventory, obviously there you will need to do ad hoc checks, either internally or with the help of specialists, to swiftly assess whether the information is indeed illegal or not. A few points that I would add there. If information only violates a law in one specific member state, there is only an obligation to take down that information in that specific member state. So technically, that is a quite important point, and may require technical solutions like geo-blocking, etc. The other thing that is useful, I think, is the fact that the European Commission in the past published recommendations on measures to effectively tackle illegal content online, and we do expect them to update these in the wake of the DSA. And finally, one point which I think will provide some comfort to hosting providers, the DSA as such expects the hosting providers to design the notice forms in such a way that people who complete it are encouraged to provide sufficient substantiated explanations as to why they consider certain information to be illegal. And so you should already in your notice have an indication or reference to the specific provisions that have been infringed. Moreover, and I think that is really very helpful, the DSA clarifies that a hosting provider is only assumed to be aware of the existence of illegal content if the notice itself allows it to determine that without a detailed legal examination. So there is no expectation as such for hosting providers to conduct really deep in-depth legal analysis around these notices.
Thank you, Tim. Frankie, how's things look in the UK when it comes to illegal and harmful content?
Yeah, interesting when we compare it to the DSA. So for illegal content under the Online Safety Bill, there will be designated priority offences in the legislation. That's currently set out in Clause 53. So I think the impact of that is actually illegal content is defined a lot more narrowly in the UK than it will be under the DSA. So some of these priority offences are new, some are existing offences. It includes everything from online fraud, terrorism, child sexual abuse offences. But there are also, these new offences like criminalising the encouragement of self-harm, which has been a sort of hot topic in the UK following a number of recent cases involving social media companies. So yeah, interesting, kind of the opposite end of the spectrum really to the DSA for illegal content at least. And the other thing to note about illegal content, which is kind of topical, is that content generated by a bot or another automated tool will be capable of being designated illegal content. So presumably that will include things like AI generated content as well. I've mentioned that actually we've still got this harmful content aspect in the Online Safety Bill as well, despite it being watered down a little bit. And that's in Clause 54, and we will expect regulations to set out the detail for what harmful content means effectively. There's currently a test for non-designated harmful content in the legislation. So that is content which presents a material risk of significant harm to an appreciable number of children in the UK. So a highly subjective, I would suggest, and potentially quite problematic thing to enforce. When we're talking about, practically how does a platform decide what is harmful content, we're going to need to rely, I think, on some guidance from Ofcom on this. But we will need to make some pragmatic judgment calls, similar to what Tim was saying, analysing what the likelihood of these risks arising on a particular platform is going to be crucial, and then assessing, what type of content will impact on the majority of child users. Those risks might change over time, so that assessment will need to be regularly updated. And I think having really good, well thought out terms of service and community guidelines will probably help with all of this. And equally, the whole purpose of this risk assessment document in the Online Safety Bill is to sort of illustrate the thought process that goes on behind a platform's decision about whether or not something is likely to constitute harmful content. So it's important that you have that record. So if and when Ofcom comes knocking on your door, you can kind of point to that.
Thanks, Frankie. And Sinead, finally for you on what's happening in Ireland.
So harmful online content, as I said, is defined in the 2022 Act. It includes offence-specific categories that are listed in Schedule 3 of the Act. And there are 42 offence-specific categories in that schedule where it's an offence under existing legislation to disseminate the material. So, for example, that includes child pornography, online content by which a person harasses another, online content by which a person engages in public provocation to commit terrorist offence. It also includes content by which a person bullies or humiliates another, promotes or encourages a feeding or eating disorder, self-harm or suicide, or someone makes available knowledge of methods of self-harm or suicide, and that specific content meets the risk test provided for in the Act. So the online content will meet the risk test in the Act if it gives rise to a risk to a person's life, a risk of significant harm to a person's physical or mental health, where the harm is reasonably foreseeable. So it includes the offence-specific categories and the harmful specified harmful content, provided it meets the risk test. And there is scope under the legislation for further categories of content to be specified as harmful by way of ministerial order. And I suppose just to make the observation, unlike the DSA, it includes the non-offence specific content that meets the risk test. Insofar as the illegal content is concerned, the 2022 Act is confined to the 42 offence specific categories. So it's perhaps more in keeping with the UK position, although not identical.
Lovely, thank you. Okay, on to our next question. We've talked about the difficulty about assessing and the challenges in assessing illegal content and harmful content, but what are the other challenges that are posed by this legislation? I don't know who'd like to go first on this one.
Yeah, I don't mind going first. Thanks, John. So there are quite a few big challenges with the online safety bill. Getting it passed is probably one of the first. But also, I mean, we've sort of touched on this already, that the need to be proactive is causing clients some concern, because the bill is designed around this duty of care. The obligations are sort of less clear, and they're a bit more active, proactive even, than the DSA. So it will remain unclear for a while, I think, how proactive is enough to be compliant. And I think, we've had some questions from clients in the past about, what's the test? Like, where is that sort of hard red line? And that's a really difficult thing to answer with the bill as it's currently drafted, because it is a risk-based approach. So we will, Ofcom has promised that the guidance will colour a little bit more about what's expected. But I think obviously that guidance will only be as good as the stakeholder engagement process that Ofcom can enter into. So would encourage anyone who's interested and thinks that their platform or their business might have some unique challenges or issues to deal with in terms of compliance to kind of engage in any of these Ofcom consultations that we would expect to pop up over the next sort of 6 to 12 months. And that kind of brings me on to a second issue, which is about proportionality and the cost of all of this compliance, because the bill is quite broad in terms of user to user. Some of the smaller services and platforms, online games, for example, will likely be caught, and then it's quite disproportionate to sort of ask these types of organisations to monitor and regulate all of the content that's on their platforms every day. Again, the approach to regulation, as stated by Ofcom, is going to be a proportionate approach, but we'll see what proportionate actually means in due course. And the other final thing, in terms of challenges or kind of interesting things to think about for the future, is, I guess, there are obviously considerations beyond the mere legal obligations in the bill, which might drive compliance behaviour. So this is an area where over the last few years we've sort of increasingly seen serious PR and press implications of social media platforms in particular being seen not to do enough to protect children or users generally. And that's bad for business, isn't it? So it might be that the pragmatic kind of commercial reasons for making compliance changes, enforcing terms and conditions more strictly, and community guidelines, that might sort of outweigh the strict black letter law considerations.
Thanks, Ricky. Sinead, what about in Ireland?
I suppose it's difficult to comment at the moment on what the biggest challenges are. I suppose given there haven't been any designations and the online safety codes have yet to be published, we'll have to wait and see what standards, if any, are set out in the online safety codes in respect of notice and action mechanisms and internal complaints handling, and, for example, whether there will be time limits within which to act. Clarification in respect of time limits will be important, insofar as that may affect when a complaint might be made to the Media Commission under the Act. It's interesting to note that the general scheme for the Defamation Amendment Bill under Head 34 that does provide indicative timelines for the notice and action mechanism for online publication. But it is interesting to note also that time limits are not expressly provided for in Articles 16 and 20 of the Digital Services Act, albeit that both articles talk about acting in a timely manner. We'll also have to consider how online safety codes that apply to interpersonal communication services or a private online storage service will operate in practice. The 2022 Act provides that such an online safety code can only apply to the offence-specific categories of online content, but it remains to be seen how in practice that's going to operate if the service is in fact encrypted. We'll also have to see, I suppose, what issues arise from the potential overlap between the 2022 Act and the Digital Services Act when fully in force, and indeed between the 2022 Act and other domestic legislation, for example, the Defamation Amendment Bill and data protection legislation. So, for example, could we potentially see complaints being made to both the Online Safety Commissioner and the Digital Services Coordinator? The focus of the complaints mechanisms would appear to be different. The 2022 Act seems to be focused on harmful online content that's available on a designated online service. Whereas I said earlier, Article 53 of the Digital Services Act relates to a complaint being made to the Digital Services Coordinator about an alleged infringement of the regulation. The fact that the government has confirmed that the Digital Services Coordinator under the Digital Services Act will be a member of the Media Commission will hopefully serve to ensure that there's some joined up thinking in terms of how both pieces of legislation are implemented and enforced. There's also, as I said, the potential for overlap with the Defamation Amendment Bill, as defamatory material isn't provided for in the 2022 Act. And you could have a scenario where defamatory material might amount to harmful online content under the 2022 Act, or indeed illegal content under the Digital Services Act. And it's not entirely clear how, again, it's going to operate in practice. Might you have to elect to proceed under one piece of legislation as opposed to another? And we'll obviously have to consider that further when the Defamation Amendment Bill is published, and indeed when the Digital Services Bill is published.
Thanks, Sinead. And Tim, finally to you on this question. What are you seeing clients finding challenging in the Digital Services Act beyond, I guess, the scope of illegal content and how they might try and assess that?
So that's do you have a minute? There's a lot, I'm afraid. But if I again focus specifically on the notice and action and content moderation bit, I think actually it's probably fair to say that one of the bigger challenges the clients encountered straight from the outset, it's determining the qualification of each service. It is, at the face of it, the definitions of hosting service and an online platform, etc., may seem quite obvious, but unfortunately, it is actually not always crystal clear whether a service does constitute a hosting service rather than an online platform. The big difference, obviously, is that an online platform is a hosting service which does not only host information but also disseminates that information to the public. But there is this interesting sort of carve out in the DSA, which says that if the information is disseminated to the public, but that is done as part of an auxiliary feature of the service, well, then the service as a whole may not be an online platform after all. And if you look at recitals, the example that is given is the comments section that you may find on an online newspaper. That is obviously dissemination of information to the public, but it is not the core activity, let's say, of what this online newspaper is doing. So that is one example. We similarly have many interesting discussions with clients as to whether live streaming services which do not offer a recording feature, so you really can only view the feeds if you are online at the time when it's being broadcasted, whether that does qualify only as a hosting service or not, whether it's actually out of scope. And so there are actually really a lot of gray zones. And obviously, because of how different the compliance obligations are depending on the qualification, it's really crucial to get that initial analysis right. And adding to that, what is really important to bear in mind is that the qualification applies to services, not to the organization, not to the company. So one single organization in relation to service A may be only a hosting provider, but maybe in relation to service B also an online platform, and perhaps for service C even be a marketplace. So that is quite a challenging task to do right from the outset. In terms of other challenges, we get a lot of questions on the trusted flaggers as well. So trusted flaggers are people with, let's say, subject matter expertise who may be vetted by the digital service coordinator of a certain member state. So these are the experts that get a mandate in a way from the authorities to go and find illegal content online. And so if those trusted flaggers file a notice of illegal content, then the online platform must give priority to these requests and must act without undue delay. So there is an expectation that you act more quickly because it is assumed that notices from these trusted flaggers are accurate and that the allegation is substantiated. But so what it means in practice is that in the internal compliance processes, online platforms need to distinguish between notices from these trusted flaggers as opposed to those that are being filed by the wider public, because it requires a different way of dealing with it. And then I think this one other challenge, specifically in the context of content moderation, which is the fact that many online platforms are struggling with the requirement to put in place the internal complaint handling mechanisms, but actually even probably more with the need to submit to out-of-court settlement of disputes. So essentially, in a nutshell, when an online platform removes information or suspends a recipient's account, that recipient, which is affected by the decision taken by the online platform, must be able to lodge an electronic complaint with the online platform. And that's a mechanism that must be easily accessible and free of charge, and where then the online platform must assess that complaint and take a decision in a non-discriminatory manner. So they need to have sort of internal judge function within the organization to deal with that. So that is one bit, but on top of that, a recipient of service is also entitled to refer its complaints to these so-called out-of-court dispute settlement bodies. And these are external bodies, impartial, independent bodies that, again, will be vetted by the digital service coordinators of the member states. And there's really a lot of uncertainty as to how this will work in practice. Will all these bodies apply the same rules and rules of procedures and processes? Hopefully, yes, but if they don't, that will be, from an operational point of view, quite challenging for online platforms. Similarly, will an online platform be able to, let's say, only collaborate with one specific out-of-court settlement body, or will they need to submit to potentially all bodies that have been vetted? And is it really the recipient of the service who gets to choose which out-of-court settlement body it selects? These are quite practical questions, not necessarily a huge legal impact per se, but potentially very substantial operational impact in terms of how all these processes and procedures will play in practice.
Thank you, Tim. So a lot to kind of work through, I think, on all these three regulations. So coming up to our fourth question, I guess this is the kind of one that a lot of people will want to know, because it's really what are we seeing in the market? And obviously we've done had quite a few questions from a variety of different organizations in different sectors, from the biggest to some of the smaller operators. And I guess people are always interested in understand what's the market out there. So perhaps Tim, I could ask you first, what are you seeing other companies doing now to implement the DSA, and perhaps maybe more importantly, what should they be doing if they're not already?
Yeah, sure. Happy to say a few words about that. Let me perhaps start by saying that obviously, as well, you briefly referred to it, the DSA will start applying as from the 17th of February 2024. So it's less than a year left. And besides, there are two exceptions to this start date. As you may know, online platforms were already required to publish their average monthly users by the 17th of February of this year, and there's a requirement to update those numbers every 6 months. And then secondly, the entities that have been designated by the European Commission as a very large online platform, we currently have 19 of them, so the VLOPs are the ones that have monthly average users in excess of 45 million. And the 19 that have been designated, most of them, there's no real surprises there. So we're really speaking about the biggest social media platforms. But it's interesting to know that the European Commission made it clear that this is sort of the initial batch, and that we may expect additional VLOPs to be designated in weeks or months to come, as the European Commission continues to do their assessment and analysis of these user bases. But so anyway, these VLOPs, they have to comply with the rules under the DSA by the 25th of August already. So that's an even shorter time frame. And so all that means that there's not a lot of time to prepare. If we look at the practical things that the online intermediaries should be doing, and what we're doing with clients today, as I mentioned, the first step is really obvious, but unfortunately not that easy, and much more difficult than you would think. It's really to just first determine the qualification of each of the services that you have, which means, first of all, determining how many services do you have, and how much do you need to consider certain services which may be offered on one and the same environment, whether they qualify as separate services or whether they are actually part of the same, or potentially an auxiliary feature which you can disregard. So that is the first step. And once you know which are the services that you have, you need to determine what qualification you have in relation to those services. So that is a challenging bit. Once you have done that, it's I would almost dare to say a bit more straightforward, but I don't want to understate the actions that will be needed. But people who have been around in the 2016-2018 periods, when organizations were preparing for GDPR, will know what the next plan is. Then it's really to put together your internal project plan, listing all the actions that will have to be implemented, looking at what is already existing, and for some organizations, they will already have quite a lot in place, and so it will be a matter of fine-tuning and tweaking. There will be certain new things that will have to be implemented for everyone, because it's simply a new obligation under the DSA. But if you look at all those actions, I would say that you can divide them between the ones that are relatively straightforward. For instance, drafting certain documents, the transparency reports, and I'm weighing my words because I know that even publishing your monthly average users is not that easy to calculate, but it's relatively straightforward. Updating your terms and conditions to make sure that it meets the DSA requirements, it's also relatively straightforward. But there are also some actions which are more complex because they will require technical developments. We haven't really talked about this in this specific content moderation webinar, but there are specific obligations around online advertisements in the DSA, where real-time information needs to be provided about these ads, who is asking them to be delivered, and what are the criteria that were used to target the recipients, and so as a recipient, I will need to see information that allows me to understand why it is that I am seeing that particular advert and not another different one. There is a requirement around age verification, or rather there is a prohibition to present targeted advertisements to minors. So there is an implied requirement to verify the age, and again that will come with the need for technical solutions, of course. And for instance, on that last bit, it's not entirely clear today how that age verification should be achieved, and as of when an online platform will be assumed to have quote unquote reasonable certainty that a recipient of the service is in fact a minor. What we do know there, it's not helpful today, unfortunately, but we know that the Commission is working on an EU code of conduct on age-appropriate design. It has published that it has mentioned that it is expected to be published by mid-2024, but so mid-2024 may be after the effective date of the DSA, so that will not necessarily be soon enough. And so on these topics, what we're advising clients at the moment is to already have a look at the approach that has been adopted in the US, for instance, under the COPPA rules, but also obviously, as you will know better than me, John, the age-appropriate design code in the UK, which may serve as a helpful starting point for this exercise under the DSA.
Thank you, Tim. Frankie, obviously we're a little way off in terms of the bill and a little bit of uncertainty on what's happening in the UK, but what are you seeing companies are asking you about when it comes to maybe not implementing, but what they need to be doing, what they'd be thinking about? What sort of questions are you getting?
Well, there's this interesting issue at the moment around end-to-end encryption in the online safety bills that attendees may have seen already, with some companies publicly refusing to implement the online safety bill if it enters into force, and saying they'd prefer to exit the market because currently in the bill as it's drafted, there is no protection or carve out for end-to-end encrypted products, and the fear is that Ofcom could potentially force WhatsApp and these others to undermine the user privacy of their product to uphold these content moderation rules. So that's something that's not really resolved yet, and will probably need to sort of play out a bit more before the bill is enacted, but just interesting to note. I mean, one of the first things, I guess it comes back to scope again. The first things to think about when you're thinking about, being proactive about the online safety bill is, whether or not you're likely to be a Category 1 service, and that should be fairly obvious. There are these additional obligations on Category 1 services in the bill, similar to the VLOPS scheme and the DSA. We don't quite know yet what the threshold will be, but for Category 1. But I think this list of 19 VLOPs probably gives us quite a good guide as to who will be included in the Category 1 designation for the online safety bill. In terms of new technologies, I think we had a question about that. So age gating, again, just as important for the online safety bill as the DSA, particularly for these services that are likely to be accessed by children. We're starting to see people in the market, pick that up. And similarly, identity verification will be particularly important for Category 1 services. There's this clause 57 in the bill that all of the big social media platforms, so Category 1 services, must offer adult users the option to verify their identity if they wish to do so. And there's some sort of guidance out there that could be helpful when it comes to thinking about proactively thinking about what a company might want to do about harmful content. So Ofcom's previous work for video sharing platforms under the AVMS regulations, you know, there's kind of covered this ground a little bit before. So if you're trying to sort of gather together, you know, what your existing compliance measures are and how they might sort of be not shoehorned, but sort of massaged into online safety bill compliance, that's probably also a good place to start.
Thanks, Frankie. And finally, Sinead, to you on.
I suppose it's difficult for providers to it's difficult for providers to take steps to implement when there haven't been any designations and we've no real sense of what's going to be provided for in the online safety codes. They've yet to be published. And unlike the position in the UK with Ofcom, the Media Commission in this jurisdiction has yet to publish any guidance. So it's quite difficult to give a steer. Providers, I suppose, should at least familiarise themselves with the legislation. We know that video sharing platform services are going to be designated. We also know from commentary that the Online Safety Commissioner will be looking at complaint handling turnaround of platforms and whether they're effective. So an initial step that might be considered is to assess whether you have a robust and user-friendly complaints handling process and whether complaints are being processed in a timely manner. We also know that in terms of the introduction of complaint schemes, that the Commission is required to prioritise the making of those schemes that relate to complaints about harmful online content relating to or directed at children. And I suppose that we know that very large online platforms and very large online search engines may already be in the process of conducting risk assessments in accordance with Article 34 of the Digital Services Act, which would include assessing the risk in relation to the dissemination of illegal content through their service. So those assessments and any mitigation measures implemented may be of assistance if it transpires that you're going to be designated by the Media Commission and required to adhere to an online safety code in Ireland.
Thank you, Sinead. We're almost up on time, and I guess this shows that we've managed to get through 4 questions on 3 topics and quite how much there is to cover on that. So maybe it's worth a couple of minutes of wrap up, and then we'll let people have a couple of minutes back in their diary. So I think, you know, listening to what's been said today, I think the question then is what do we do next? You know, and I think it's kind of clear that the focus here for businesses should be on the Digital Services Act. You know, that's the one that's the most imminent and with the most clearest obligations, and build compliance frameworks around that. So doing, as Tim's talked about, mapping obligations against your existing frameworks that you have for other compliance requirements. But as we've sort of seen here, we've talked about 3 of the regulation, but it's important to be monitoring new laws in this area because, you know, there's existing legislation around things like terrorist content or new legislation being proposed around blocking cyber hate accounts across different jurisdictions across Europe. And there's like to be, you know, a reasonable amount of overlap, and we've talked about some of those differences, but we can start to see companies trying to adapt their frameworks to try and create a common tool. And lastly, to pick up on what Frankie said, I think there'll be an increase in the use of technology here, continued increase in the use of technology. Clearly, where you'll need to be more proactive, we're certainly seeing a sort of rise of tech safety providers. So whether that's age verification or age gating solutions through to identification of certain types of category of content on sites to be able to allow platforms to take proactive measures to take down. I think that's something that we're going to see more of over the coming months. So with that, I just want to say thank you to the panel for letting me kind of grill them on things. Please do ask us any questions. It looks like there isn't any questions in the chat, which means we've done a great job of answering them all. But please do drop us a note if you have any other questions that come up. We'd obviously be delighted to speak to you. And a quick plug, if you want to hear more about what's going on a broader technology regulation, the firm is putting out quite a lot of content in terms of that, not just webinars, but also quarterly newsletters on European tech regulation, a horizon scanner, blogs and other activities. So if you want to get onto that mailing list or see that content, if you Google Field Fisher Technology Regulation, you'll find our page and be able to sign up for all that stuff. So with that, and with 1 minute to spare, I'd like to say thank you for listening and have a good evening.
Thank you.
Thanks, John.
Bye.